Hello everyone. Thank you for joining us for this webinar. Just some housekeeping issues to begin with. We will be sharing with you all the slides and the recording after the event, so look out for those. We have factored in some time for questions at the end, but feel free to put any questions in as we go along in the chat, and we will pick up as many as we can. We will follow up with any questions that we don't manage to answer today, though. So today we're dealing with a webinar in our privacy series. Today we're talking about privacy in the context of health and life science businesses, particularly the NIS2 obligations, and also key emerging issues, some of the issues that we think will be relevant to you. So the three of us today are myself, I'm a partner in the data team here at Field Fisher, Nuria, a director in the team, and Alex, an associate. The dream team dealing with health and life science businesses and working with a lot of you on your issues day to day. So today we're going to cover, in particular, NIS. We'll look at the UK NIS position and what's coming, which will be different, how it will diverge from NIS2, which is the new landscape for Europe. We'll talk about the scope, jurisdiction, key obligations, and the enforcement issues, and give you a practical list of the takeaways, things you will need to do and when you'll need to do them by. We're then going to look at some of the key emerging privacy issues. We'll look at two topics in particular, health and wellbeing apps, which are increasingly popular, and AI in the health sector, which I know all of you are very interested in at the moment. We'll finish with a bit of a roundup about what regulators are doing, what's in the news in this space. So let's dive right in. So first part, let's talk about NIS. I'm going to deal first with the position in the UK, just to be clear about the differences. I know many of you are working on a multi-jurisdictional basis, so let's clarify to begin with, because there are going to be differences from when these changes come in. So to recap, the current regime in the UK, we have the scope being the operators of essential services, so critical services such as water, transport, energy, and some healthcare. And health services were defined as being provided by health professionals to patients to assess, maintain, or restore their state of health, including prescription, dispensation, and provisions of medical products and medical devices. We've got registered or digital service providers, which includes online search engines, marketplaces, and cloud computing services. The scope would be having a head office in the UK or offering services into the UK where you should have nominated a UK rep, and not being a micro or small enterprise, so dealing with medium and large size businesses. The scope of the regulations include network and information systems, which basically is any computer system used to process digital data. And the aim of the law is to improve cybersecurity generally, and often relates to incidents that might affect these services. Measures to comply should cover incident handling, business continuity management, monitoring, auditing and testing, and compliance with international standards. So that's where we are, that's where we have been in the UK, or offering services into the UK, but we have significant reforms on the way. We're not going to deal with these in an awful lot of detail today, but just to be really clear that what we're talking about in this context and then what we're moving on to. So significant reforms. There will be some changes that will be in a similar way aligned with NIS2, but some variation. So the registered digital service providers will be expanded to include managed service providers, MSPs. broadly sort of remotely managing aspect of customers' IT systems and app management. So a lot of the changes are to pick up businesses that were seen to be critical after consultation, such as security monitoring and outsourcing business processes, which were identified as being critical if something goes wrong. Critical registered digital service providers are subject to new proactive supervisory regime and potentially two-tier supervision. There are wider notification obligations and cost recovery. So not so much of an emphasis on expansion in healthcare necessarily, but we'll talk to you about the obvious changes and expansion to healthcare under NIS2. Thank you. So NIS2 then. So this is Europe effectively, mention the scope later, but the changes replace and build on the existing provisions. They'll apply to essential and important entities operating in a defined list of sectors, including critical infrastructure entities. So the scope expands. We'll deal with that in a moment. Remember, back where we are in the UK, the original scope was operators of essential services and registered digital service providers. Will be moving to new definitions of essential entities and important entities, and the difference between them will be based on sector criticality. Again, there will be a cap. This will relate to medium and large entities. So what is the scope then, and particularly if you're in the health sector? So if you provide services or carry out activities in the EU, that's in scope. If you meet or exceed the thresholds to qualify as a medium-sized enterprise, which broadly are having more than 50 employees and an annual turnover and or balance sheet total exceeding 10 million euros, that's in scope. And then if you operate in one of the sectors listed in the annexes to the directive, and I'll deal with that on the next slide. So the annexes, there are 3 annexes to the directive, and they list sectors that this will be applicable to. There is a list, but then there are further definitions that need to be referred out to other legislation to see whether you are picked up by the regulations. So the first takeaway I think that we would give to you, that it's absolutely critical that you have an assessment as to whether NIS2 will apply to you if it didn't apply to you previously. So we have broadly picked up obvious examples that will be picked up by the new provisions. We've separated them here between essential entities and important entities, but this is not an exhaustive list, and there is further clarification in other legislation to define this further. So broadly, we have manufacturers and medical devices in particular, medical devices considered critical, certain healthcare providers, medicinal R&D and research generally. And then for important entities, we have wearable devices, smart devices I think we're all familiar with, software as a medical device, digital twins, in silico medicine, telehealth solutions, and in vitro diagnostic medical devices. So as I mentioned, this is not exhaustive. I mean, if you're obviously within this, then by all means, speak to us if you'd like to know more. But part of your takeaways for this would be to assess critically whether you are brought within these regulations. And I will hand over to Alex.
Thanks, Sarah. So let's take a moment and pull this all into perspective and talk about timings for our diaries. So NIS2 entered into force on the 16th of January this year. Member states have until the 17th of October next year, so 2024, to transpose this directive into national law. Now, we're monitoring the situation, but so far we have not seen any member state implementation. That said, there are murmurs, and as we approach just under a year until the implementation deadline, we expect to see movement on this very soon. Now, you'd be forgiven for thinking, well, we have a year until this applies, so we don't need to worry about this now. But it's important to remember that compliance with NIS2 is not going to happen overnight. And even without the national implementation, there is a lot that organizations can be doing now. Before you know it, it will be October 24 and enforcement will begin. Oh, apologies. So one thing that may have crossed your mind as we run through these slides is, how do I know which national implementation applies to my organisation? I'm going to spend a few minutes talking through the criteria for working out which national implementations apply, but don't worry if by the end of this slide you are still not 100% clear. In many instances, this will be a very tricky assessment and will be something that we'll need to support you with offline. Now, the starting point is that organisations will be under the jurisdiction of the member state within which it is established. Now, many of us will have come across this term in the context of the trusty GDPR and will recognise the establishment to mean effective exercise of activity through stable arrangements. Now, this is a very broad definition if you know GDPR, and stable arrangements is often met by just having 1 or 2 staff members in a particular jurisdiction. Now, if your organisation is established in more than one member state, it will fall under the separate and concurrent jurisdiction of each of those member states. So given the potential for variance in the means of implementation, and not to mention the differing judicial approaches in differing member states, this means that a compliance project for NIS is quickly going to become quite a big one. It will be important to understand which member state laws will apply ahead of the national implementations so that you can keep track of the relevant ones. Now, finally on this slide, we just want to mention that for some organisations under NIS2, such as digital service providers, which Sarah mentioned earlier, there is a one-stop shop mechanism. Now, again, this is a concept that you will recognise from GDPR, and it means that some entities will only be subject to the rules of the country where their main establishment is located. Now, this again is not a straightforward assessment, so we recommend seeking legal advice before making a final call. But the directive does set out some criteria for establishment. So I'm going to run you through these, and they're on the slide on the right-hand side. So firstly, the main establishment is where the decisions related to the cybersecurity risk management measures are predominantly taken. Now, this is often the place where the entity's central administration is located. If you cannot determine the main establishment on this criteria, you move to the second. The main establishment is where cybersecurity operations are carried out. And if the main establishment cannot be determined on that basis, you move to number 3, which is your main establishment will be the member state where you have the highest number of employees. Like I said, it's a tricky test and it's not always obvious, but hopefully this brief overview will give you a bit of a starting point. Now I'm going to hand over to Nuri, I think, who's going to take you through some of the key developments.
Thank you, Alex, and good afternoon, everyone. Lovely to be here this afternoon with you. So as Alex said, I'm going to talk about certain obligations, or the main obligations, if you like, that apply to important and essential entities. But before I do that, I wanted to mention something very quickly, which is the fact that if you look at the NIS directive, at the actual text, there are actually also a lot of obligations that apply directly to member states. So for example, European member states, obviously. So for example, in relation to the obligation to adopt a cybersecurity strategy, or the appointment of what's called a CERT, a computer security incident response team for incident handling. So we're not going to deal with this today. I'm just going to focus on the obligations for important and essential entities. So going through the slide clockwise, the first requirement I wanted to mention is that NIS2 takes a more aligned cybersecurity management approach in order to mitigate inconsistencies with previous legislation in the context of cybersecurity across the sectors that are in scope. So the actual obligation, and I'll read it out, is that organizations which are within the scope of NIS apply appropriate and proportionate technical, operational, and organizational measures to manage the risks and to prevent or minimize the impact of incidents. So, however, the directive goes beyond that, and what it does, it sets out a list of minimum basic security elements that will have to be applied. I won't read them all out, it's quite a long list, so you can take a look at Article 21 in your own time, but I'll just mention a few of them just to give you a flavor of the type of obligations. So it talks about policies on risk analysis and information system security, incident handling measures, business continuity, or for example, cybersecurity training. So as I go through the list, I'm hoping that some of these will be familiar and you might think, actually, I already have this, and others you may not have in place. So of course, as Sarah said, there will be a number of things that, or a bit of a checklist that we'll provide at the end of the session to remind you of things that you may be able to start working on. The NIS2 also requires individual companies to address cybersecurity risk in the context of the supply chain and the supplier relationships. So what this means in practice is that it may require tightening of some of the contract drafting. So you might need to look at your templates, but also carrying out checks and assessments about the overall quality of products and cyber practices of your suppliers or your service providers. So the next item I wanted to discuss is the incident reporting requirements. NIS2 imposes a system of a phased reporting when you have an incident. I will stop here and I won't go into more detail because I'm speaking about this in the next slide in more detail. So I'll move on to the next requirement. And this is more of a formal one, not so much a substantive one, but nevertheless important. And this is a registration requirement with ENISA, the European Agency for Cybersecurity. And this applies to cloud computing service providers, to data center service providers, content delivery network providers, and so on. There is a list of types of organizations caught by NIS that will be required to register with the NISA. Again, I won't read the full list, and it might be that it doesn't apply to you. So again, this is something for you to consider whether you are actually caught under this requirement. One of the, from my experience and having looked at this for some clients, is you may, for example, as a provider of a medical device, you may fall under the definition, for example, of cloud provider, in which case you may be caught by this requirement and be required to notify. So a final point that I wanted to look at, this is quite interesting, in relation to management liability, as you can see, the last item in the slide. So NIS2 imposes direct obligation on management bodies. And some of these obligations, for example, are the approval of cybersecurity risk management measures taken by the agency, by the entity. Also, the supervision of the implementation of the risk management measures. So as you can see, the management bodies are required or expected to become involved. And failing to do so may lead to fines or bans from discharging managerial functions. And so as you can see, this is quite relevant and might have quite a lot of relevance in practice to some of these managerial bodies. Unfortunately, there isn't a definition of management body within NIS, but we expect that this will be further clarified in the local laws of the European member states that will come, as Alex was saying, will come down the line. Another thing to consider before we go to the next slide is that there is an obligation within the directive to provide training to these management bodies, and so that they can carry out and identify these risks and assess the cyber practices and whether they are fit for purposes. So again, something for you to consider in terms of next steps, putting this training in place, not only for management bodies, but also generally for your employees on a regular basis as well. This is something that is mentioned specifically in the directive, that training should be carried out on a regular basis. So let's move on to the next slide. Thank you, Alex. So as I said, in this slide, I'll have a look at the what we call the breach notification obligations. And as I said earlier, there's been some tightening of these requirements from NIS1 to now NIS2. And one of the things that we need to bear in mind is that these notification or breach notification obligation or incident notification obligations will apply sometimes in conjunction with the notification obligations that organizations might have under the GDPR. So just bear in mind that the fact that one applies to you doesn't mean the other will not apply. So under certain circumstances, you may find yourself being subject to both regimes and having to comply with these notification requirements to different authorities at the same time. And that's why it's important to be prepared, because as we all know, we've all managed breaches and have dealt with these situations. And it's something that, if you're prepared, it's going to be a much easier, less stressful experience. So let's go through the content of the slide. So who should notify here? So both essential and important entities are subject to these notification requirements. In terms of the authorities that should be notified, these will be set out under the local law of the member states. So it could be the CERT, or it could be another competent authority. So we'll have to keep an eye out once you've carried out the assessment of which local law applies to you. When the local law comes in place, you'll have to look into what regulator you'll have to notify to. And I guess another question, because in the back of our mind, I think all of us are comparing this regime with the GDPR regime of notification, is whether individuals need to be notified. And what the directive says is that the recipients of the services also need to be notified without undue delay. And this, again, this is something that will be further regulated under local law. And they might be notified of they potentially being affected by a significant cyber threat and the measures that they should take in order to respond to the threat and to protect themselves. Next, I wanted to look at what's actually a notifiable incident. And the NIS refers to significant incidents. So only significant incidents will be notifiable. So what's an incident? Let's go step by step. So an incident is defined as an event compromising the availability, authenticity, integrity, or confidentiality of stored, transmitted, or processed data, or the services offered by or accessible via network and information services. So if you are familiar with the GDPR personal data breach definition, I won't read it out here, but you will find some similarities. So as I said, you might find yourself in a situation where there is crossover, and what's an incident under NIS will also be a personal data breach under the GDPR. So NIS requires that in order to be reportable, the incident has a significant impact on the provision of the services. And this impact is defined as incidents capable of causing severe operation disruption or financial loss, or if the incident can cause natural or material person some damage. A final point I wanted to explain, and this is, I think, one of the big changes, which is interesting, is the changes in the timescales for notification. So as you can see from the slide on the right-hand side, the directive imposes what we call a phased approach. So, and under this approach, what will happen is that you will have to be much quicker to start with as you were under the NIS1 regime, or even as you have to be under the GDPR. Because actually what's expected of organizations notifying an incident is that within the first 24 hours of becoming aware of the incident, companies have to submit what they call an early warning. So basically it's the provision of basic information about the incident, whether it's been caused by unlawful or malicious means, and whether it will have some cross-border impact. So it's a very early warning, as you can see, only 24 hours from the moment you've become aware of it. Then after that, and within 72 hours of becoming aware of the incident, organizations will be expected to provide a bit more information, more comprehensive information on top that supplements the information provided initially under the early warning. And finally, the third phase of notification is the phase where you, within 1 month of the second notification, you will provide a detailed report to the regulator. So as you can see, it will require a very quick response, a very quick reaction to the incident. Therefore, you'll have to be prepared. You'll have to have those procedures in place in order to act quickly. I think especially if you are familiar with notifications under the GDPR, we have seen that European regulators and also the ICO are mostly happy for organizations to report to them with a phased approach as well, because I think there is an acknowledgement that information will become available to the organization sometimes as things progress. So in a way, it seems that what the NIS legislation is doing is setting out a phased approach on the basis of perhaps previous experience in other contexts, or perhaps in the context of NIS1 as well. So I'll stop here and I will hand over to Alex.
Thank you. So going to have a quick chat about enforcement under NIS2. So compared to NIS1, NIS2 provides much more detailed rules on the powers which should be given to national authorities who are responsible for supervision and enforcement tasks. Now, the investigation and supervision powers which can be made available under the national implementations are things like on-site inspections, security audits, and requests for information to assess cybersecurity measures which have been adopted by the entity. Now, a quick reminder on what we were talking about earlier in terms of essential entities and important entities, but in the context of enforcement. So in general, NIS2 investigation powers allow essential entities to be investigated at the time, including through regular audits and random inspections, whereas important entities can only be investigated ex post, so after the event, after the incident occurs. Now, let's talk about penalties under NIS. These also depend on whether you're an important or an essential entity. So if you are an essential entity, you'll see on the slide there that the fines can be up to the higher of 10 million euros or 2% of global turnover. Whereas for important entities, slightly lower, you can be fined up to the higher of 7 million or 1.4% of global turnover. Now, in addition to this, supervisory authorities, that's a long term, will also be able to impose a range of non-monetary remedies. So this would be things, for example, compliance orders or binding instructions, that sort of thing. They can also give orders to inform people about cyber threats. That includes customers. And I won't touch on it again, but just for completeness, Nuri has also mentioned the fact that there's the possibility of personal liability for gross negligence. So that's another one to factor in there on the enforcement page. I think I'm going to hand over to Sarah now, who's going to wrap up this section on NIS. I think that's enough for one day. Sarah, over to you.
Thank you, Alex. And for those of you that are familiar with the UK NIS provisions, you can see a difference in the fines already. So we're talking about 17 million in a UK context and potentially much less in a NIS2 context. But anyway, to wrap this up, what are the takeaways from this? What practically do you need to be doing in the time that you have available? Because frankly, there is potentially a lot to do. So as I mentioned earlier, I think the key takeaway is to be clear whether you're caught up in the regimes, and are you caught up in both regimes, and what's the difference to you? There's material available on our website. Sorry, I think I heard some feedback. I hope you're not getting the same. There's an article on the 21st of September, a week ago, that's got a good comparison between the two bodies of legislation, and there's previous materials about the health context in this area. But by all means, come and talk to us if you need some support in this area. You're clearly going to be needing to extend your management and response plans, consider organisational, financial and technical steps required, and don't forget your business as usual compliance. I'll mention in a moment how actually that can get you quite a long way towards compliance in this area. So also think supply chains. So wherever you are in the supply chain, at the head of the supply chain or further down supplying services, this is going to be relevant to you. Due diligence may well change to comply with this. Either way, you'll insist your suppliers provide more information, perhaps have higher standards, or you'll be required to do so. So on the right of the screen, you can see a bit of a checklist, a practical checklist about this, what this probably means. So you've got incident notification requirements. You need to know, what they are, how they apply to you. You'll need to update your internal policies, procedures, and reporting lines. I mentioned the supply chain critical issues, so vendor due diligence might need to change. You might need to have assessment of cyber resilience in the supply chain, and contracts may need to change to reflect the new requirements. Training is going to be really important here. As things change, you're going to need to make sure your employees across the business know about this and understand what they're doing. Timescales are going to be critical if you have an incident. Governance, this is going to be important to management. Management bodies will need to approve extensive cybersecurity risk management measures. They're going to want to be reassured that you haven't got the personal liability or other types of enforcement risks across the board. And registration, clearly, if this applies to you, you need to understand your jurisdictions, the regulators that might be relevant to you, and registration requirements. And we've had a question that's relevant here about the extent to which compliance with GDPR, for example, data protection laws, the work that you've done there would be relevant in this context. And Nuria mentioned the difference between an incident under NIS and a personal data breach under data protection laws. But actually, under the data protection laws, in preparation for a breach rather than an incident, so a breach that involves personal data, there's an awful lot in this space that really a business should have had in place before if they're not going to be criticised by a regulator after an incident happens. And this is sort of in the context of having a response plan initially before an event that deals with things like allocating responsibility, having a team that's responsible for this and investigating and addressing issues, dedicated person or team. Do staff know how to escalate if an incident occurs, who they need to speak to, what the process is, who's got responsibility for decision making when we're talking about hours before having to publicly deal with information like this? Have we got processes for assessing risk? That's going to be really important here. As I mentioned, do we know our supervisory authorities? Because we're just not going to have time to be making those decisions once an incident has happened. Do we know what information we're going to need to have to produce to a regulator once an incident occurs? Have we got the right records that will be needed? The training and ensuring that employees are proficient in their roles, and not just giving the training, but checking, retraining, making sure people know what they're doing, updating policies. All these things are relevant in a GDPR context. They should be part of any compliance plan before any personal data breach happens, and similarly relevant to an incident, but they will all need to be updated and checked to make sure they're relevant in this context where you might come under the scrutiny of both regimes. Okay, we've come to the end of the NIS section. So in the next section, we're going to talk about other key emerging issues that we think will be relevant to you. These are the things that our clients are asking us about, and they're worried about the things that might be concerning them in the future. And I'm going to pass you over to Alex, who's going to deal with a really interesting topic first.
Thanks, Sarah. So I'm going to shine the spotlight on health and wellbeing apps, which is a trend that we have been seeing more and more of recently, and which lots of our clients are either interested in or already working on. So the COVID pandemic, sorry to bring it up, but it made us all aware of our health, a bit more aware of our health. And since we were stuck at home, our phones and our devices became the first port of call. Now, additionally, many of the traditional barriers in this space are dropping away. Just to mention one, medical professionals are much more willing to trust these technologies and much more willing to trust sort of distance testings and diagnostics. Clearly, we proved ourselves capable of shoving a cotton wool bud up our noses in the COVID tests. So it's innovation which is now taking front and centre stage, and health and well-being apps are significantly on the increase, especially as we see things like more government investment and incentives. Now, data protection is obviously an important element of this trend, and so I wanted to quickly highlight some of the data protection considerations that we've been working on in this space. Now, as you can imagine, this is quite a large topic and worthy of a webinar within itself, and that's something that we're actually looking to do after Christmas. But for now, I'm going to zone into a couple of points which are listed on the slide. So first up, legal basis. Now, these health and well-being apps, they span lots of different areas. We've got mindfulness, sleep, well-being, periods, fertility, fitness, weight loss, and general medical services. But what they all generally have in common is that they collect a large amount of health data. With that comes the need to have not only an Article 6 legal basis under the GDPR, but one of the limited Article 9 conditions. Now, this can be quite tricky because many reach straight for the likes of things like explicit consent. But in the context of health and well-being apps, consent can often be problematic. For example, what if a patient withdraws consent, but you need that data to comply with medical device regulations? And can your consent really be given freely when actually quite a lot of individuals using these apps could be classed as vulnerable, and that's a wide definition of vulnerable. Now, one of the other considerations is, have you actually identified all of the health data? Because some health data processing might not be obvious at first. For example, if you have a user signing up to an app on sleep deprivation, are you actually implying that they have a health condition without realizing? So the GDPR definition of special category data is broad and it includes data concerning health, so that's definitely one to look out for. Now, on data minimization, how much of the data you're intending to process on your health and wellbeing app really needs to be linked to an identifiable individual. Now, this will depend on the nature of the app, of course. If it's used to help deliver tailored medical treatment, then of course it's much more likely to need to be personal data. But if the app relates to more general issues, for example, tracking menstrual symptoms, do you really need it to be personal? And that's when we think about things like anonymization and pseudonymization. On to the third bullet point there, transparency. We all know this is a key requirement under the GDPR, but these apps can be complicated and we're processing a lot of data. So what we really need to make sure is whether we're being clear to the user what is happening with their data. It can be a challenge to convey this sort of information in a digestible form, so that's something to consider as well. Now, transparency takes us on to children, because the next point here is what is clear to an adult might not be clear to a minor. And you do have lots of children using these apps. So we need to consider whether their experience would need to differ. And do you need to consider, for example, age restrictions on your app or having a separate account for parents and guardians? Now, finally, I want to mention tracking technologies. We tend to focus on the GDPR compliance when we're working through data protection issues, especially when they're associated with health and wellbeing apps. But equally important are the e-privacy rules, which apply not only to cookies, but also all tracking technologies. And you will definitely be using these on some of your apps. It's not currently commonplace to see consent for tracking technologies and apps, but this is just definitely something that we're monitoring because it is technically required. And as these apps become more of a focus, it's something that sort of enforcement may be on the rise for. So unfortunately, I think that's all I have time for today. Like I said, stay tuned because we will have another webinar if you think this topic is interesting. And I will just end on reminding you of the importance of data protection impact assessments, because actually when you're carrying out these assessments, mostly they're mandatory in this space, but if they're not, they do end up raising all of the points that we've mentioned on the slides and more. So it makes sure that you've considered everything you need to. I think I'm going to hand over to Nuria now, who's going to talk about another emerging trend.
Thank you, Alex. So I don't think we could have a session or a part of our webinar on new trends or emerging trends and not talk about AI, since it is obviously the buzzword at the moment. And in the last year, it has been brought to the forefront of everyone's thoughts. And I'm sure that AI issues are coming through your desks left, right, and center. So there are, in the context of the health sector, there are many use cases that are common practice or likely to become common practice in this sector. For example, the use of AI technologies for things like for diagnostic purposes, for example, so in the detection of tumors. Also in the context of perhaps patient assessment. So for instance, I recently saw a product which was meant to be used in emergency rooms, where and it incorporated AI technology for the purposes of prioritizing and classifying the cases and the individuals that were coming in to the emergency room. So again, a very practical implementation of AI here that would apply to our day-to-day. Another use case that I have seen in some of the work that I've done recently is in the context of medical devices, and perhaps using AI technologies in order to decide the dosage of the medication dispensed via the medical device that would be dispensed to the patient. So, and I'm sure that you could all collectively come up with many more examples. So as a privacy professional, what things you should consider if you're using AI technologies in the health sector? So first of all, I think there are two things I wanted to highlight here. First of all, any use of AI technologies involving personal data will trigger the application of the GDPR, just to, at risk of stating the obvious. So you'll have to ensure that this is done in a compliant way. And we are gonna touch on this, on some of the principles and requirements in a few minutes. But secondly, another thing that you'll have to consider is a broader AI compliance piece, which is not only to do with privacy laws, and it will require your organization to put in place governance structures and policies for the use of AI. And as I said, this goes beyond privacy compliance, but in my experience, and again, our team has been helping clients with this sort of broader AI compliance piece. An organization's privacy function, it's likely to be heavily involved in this broader AI compliance effort. So I'm sure if not already, some of your colleagues will be knocking at your door soon in relation to this. So focusing on the first element, so focusing purely on data protection compliance. When considering AI issues, I think you will have to ask yourself two preliminary questions. The first one is, do I actually need to use personal data, or am I using personal data here? So again, if you may achieve the same objective by using an anonymized data set, or perhaps by using synthetic data, by all means you should, because otherwise you will not comply with the principle of data minimization. However, what's important, because I'm sure that most of you operate at a global level, is that the concept of personal data is different across the globe. So a data set that's personal data in the EU will not be a personal data elsewhere. The second question, I think this is a crucial one, especially in the AI space, is what is my role here? What's my role? It's a bit of a existential question, if you like. So under the GDPR, you may act either as a controller or a processor, or perhaps you might act as a joint controller with another controller. So why this is important? It's important for you to identify what your role is, because depending on your role under the GDPR, you will be subject to certain obligations or others. Your role will also affect what you can or cannot do with the data. And it will also affect the contract terms that you have in place with other parties that may have access to the data. In an AI context, depending on the activity that you carry out, You may be a developer, a provider, sometimes you may be both, or a customer or user of the AI technologies. So again, you might wear different hats. And normally under the GDPR, vendors would act as processors, but this is not so clear-cut in an AI context. So what I just wanted to flag for the purposes of our webinar today is that developers may also act as controllers. So there is extensive regulatory guidance on this. And again, we can, if you are in doubt, you can come to us and we can help you consider this in more detail. In the diagram in the slide, I've highlighted some data protection principles and obligations, which I wanted to run through at a very high level. However, fear not. If you want to hear more about AI and privacy compliance, we are running a webinar at the end of November, so please do register and we can look into these issues in more detail. One thing to bear in mind when you consider GDPR compliance and in the context of the use of or deployment of AI technologies is that you have to bear in mind that it affects different stages of the AI life cycle in different ways. So you have to think about the different stages. For example, the stage of data acquisition, the training and the testing on the model, and the deployment on the model. So for example, something that might work in the context of testing, so for example, a legal basis that you may rely on, may not be applicable or may not be valid in the context of another stage, like for example, the deployment stage. So just moving on to consider these requirements and principles very quickly. In order to ensure fairness and lawfulness, you'll need to ensure that your processing is within the individual's expectations, and you must also ensure that the system is statistically accurate and that it avoids discrimination and bias. So otherwise, it will not be fair and it will not be lawful. In terms of data minimization, a quick note to say that AI will require you to process large amounts of data, which in a way seems at odds with the principle of data minimization, which requires to process the minimum data necessary for your purpose. So you will have to think about how you reduce the data that you process as much as possible. And as I mentioned earlier, find ways to reduce this personal data by, for example, using synthetic data. This is one of the recommendations that we have under regulatory guidance on that point. With regards to dealing with subject access rights, you will still have to honor them, even in the context of processing vast amounts of data when you are training a model or when you are deploying it. So one thing to consider is that if the personal data is within your AI model, you may still need to honor, for example, a request for the data to be deleted. And this may affect the model, and you might have to end up retraining it. So the fact that it would be difficult or that it may affect your model will not remove the obligation of dealing or honoring these data subject right requests that you may receive. Having said that, I think that in practice, the most likely scenario is that data subjects will come to organizations to exercise their right in relation to the output data. Also in practice, you're likely to be required to carry out data protection impact assessments or DPIAs when you use AI technologies, because the use of the technology itself may be enough to trigger the requirement under the GDPR to carry out the DPIA. So as you may know, you are required to carry out a DPIA if you carry out high-risk processing, which may well be the case here. So overall, if your organization is planning to develop or using AI technologies, you may have to consider what other elements of your privacy compliant programs may need adapting, and in order to take into account the use of AI. So for example, do you need to adapt your privacy notices or your DPIA template to adjust it when the processing activities you are assessing involve AI? Again, do you need to update your internal privacy notices or privacy policies or procedures in order to ensure you cover all the challenges brought by the use of AI technologies. So that's something to think about and that we can help you with. The last point I wanted to consider is the fact that there is obviously not only the GDPR, as I said earlier, there is a broader piece in terms of AI compliance, and we have other regulation in Europe. There is other regulation coming down the line. So in Europe, the AI Act is not in place yet, but we think it's going to be in place in a few months' time. There is definitely emphasis in ensuring that regulation comes in sooner than later. And then organizations will have to normally have a couple of years to implement these obligations. The AI Act imposes a tiered system of regulation, and I can't go obviously into detail here, but most relevant it will be for in relation to the use and the development of high-risk AI systems, which will include, for example, medical devices. So that's one thing to consider. So the last point I wanted to make is that if you take a look at the obligations under the AI Act, there are some obligations, there is some crossover with the GDPR. So it is possible that some of your compliance efforts that you carry out under the GDPR may help you in the future if you are caught by the AI Act. So I'll stop here because I'm conscious of time and hand over to Sarah. Thank you.
Thank you, Nuria. I think so much to think about there. And we've had a fair few questions about AI. We'll respond to everybody, but just to emphasize, Nuria mentioned we have a webinar coming up at the end of November. There are articles on the website that have been prepared by our offices in all of our jurisdictions. We also have a YouTube channel that has webinars, recorded information in the AI space, and we have a dedicated AI webpage if anyone wants to keep themselves updated in advance of our webinar in November. Just quickly, we've had a question, Alex, about the apps. Somebody says that these are everywhere, they're being used by everybody. Are the regulators interested? What are they doing?
How long do I have? Yes, they are interested. I'll give a short answer for now. They are interested. At the moment, the ICO, which is the UK regulator, is particularly interested in fertility and period apps. It's actually currently conducting a survey to get sort of experiences and user views, and it has released some guidance on sort of well-being, consumer, like health tech apps, that kind of thing. They're all mentioning the things we've mentioned on the slide. So yes, they are interested. They're following closely with bated breath to find out sort of how people are feeling about them, and yeah, we'll wait to see what they have to say on the fertility and period apps for a start, and then we can go from there.
Thanks, Alex. I'm going to touch a little bit on that in this space. So I'm just going to finish with a roundup of things that are on regulators' radar and things that are in the news in this space with healthcare, life sciences and privacy, just to finish, and we will finish on time, I promise you. So to begin with, we have a couple of European cases that are relevant and really fundamental in this area, with consequences potentially for all of you. So the first case, I am not going to pronounce these cases, but the first case, the OT case, was a case dealing with the implication of special category data, which could be health data, not necessarily health data, the subject of the case, but the implication being that a name could effectively amount to special category data. So in this case, an individual they were asked to indicate the name, the identity of a spouse or partner, and obviously the name of a spouse or partner could potentially indicate sexual orientation of either or both of the people referred to. And the European Court indicated that this was special category data, even though it's by implication, and you might not necessarily automatically think that a name comes under special category data. obviously significant potential implications for health data where you're dealing with health data if you have to think about the fact that this could be deemed by implication. And the consequences of this might be that if you're dealing in the health space, so individuals contacting you because they're interested, does that mean contact information per se is special category data if they've expressed an interest in a health product or service? It's something that needs to be considered and something that's obviously extremely important. The European Court emphasising the real protection that's needed for special category data. And the Meta case is another similar one, really. This is in the context of social media sites' use of data and discussed the extent to which individuals interacting with health apps and websites itself would be special category data. So sort of almost more reinforcement of the fact that this can be special category data by implication. We have a case, the next case, that might actually be very useful to all of you listening in today. The SRB case dealt with anonymization or pseudonymization and opinion. The court held here that pseudonymized data transmitted to a data recipient will not be considered personal data if the data recipient does not have the means to re-identify the data. Now, this is obviously a really important area. To make a decision that something is not personal data requires careful analysis and a recording of the decision, the process you've gone through to come to that decision. But I know this is a really important area we're asked about all the time in the health space. So if you'd like some support on this and the implications for you, then please do contact us. But a promising decision potentially to be used by businesses. It also indicated that an individual's opinions can't be assumed to be personal data. So this is often an area that's looked at in the context of data subject access rights, but it says you need to look at this on a case by case basis, and probably the guidance suggests that you need to do that anyway. If you delve into it in any detail, as we do a lot, you need to look at whether it's truly personal, for example, or in relation to an individual, all sorts of factors to be considered. But emphasis here again that it's not necessarily automatically personal data. Implications positive and negative in the data subject access request type space. Then looking at what regulators are doing at the moment, we've got a few things expected from the ICO, which will be important for those dealing with health data. We have the draft guidance on biometric data that came out for consultation in August, which is really interesting, and it will be very interesting to see full responses and the final version when that comes out. We're expecting guidance from the ICO on research. We've been looking out for this for a while. You probably know the ICO has gone out to external bodies to get advice in this space and areas such as, when consent is relevant. So really important to those of you working in this area, and we will keep you updated. You will hear from us, I'm sure, when this happens. And relevant to the question that Alex had, to a certain extent, the ICO has indicated that it's bringing out guidance for smart devices and Internet of Things. It's indicated that it's concerned in this space because we should all be able to enjoy the benefits of using connected devices without having excessive amounts of our personal data gathered. It's not a price that we should have to pay to have these services, that we give up all of our sometimes sensitive personal data. So the ICO is saying that to maintain trust in this, transparency is key about what data is collected, how it's used, and it shouldn't be used in ways that people wouldn't expect. And then we have a final slide, which might scare you, but that's not the intention. In fact, if anything, it should be reassuring. So this is a sort of tech space. Med tech and innovative tech is important to, I would say, most of you watching today. And this is, I suppose, reassurance that there's an awful lot going on. This is an indication of some of the things where we're expecting changes in the next 12 months or so, but rest assured we're monitoring all of this. I mean, AI, Nuria's mentioned key areas, and we've dealt with NIS2 in cyber, but otherwise we'll keep you informed. And that's it. We have had questions we haven't been able to deal with. We will respond to all the questions that have come in, and if you need any support, please contact us.